Plaintiffs challenge a November 2008 voter-enacted amendment to the California Constitution, Proposition 8, or Prop 8, California Constitution, Article 1, Section 7.5. In its entirety, Proposition 8 provides only marriage between a man and a woman is valid or recognized in California. Plaintiffs allege that Proposition 8 deprives them of due process and of equal protection of the laws contrary to the 14th Amendment, and that its enforcement by state officials violates 42 U.S.C. 1983. The plaintiffs are two couples. Kristen Perry, Sandra Steyer reside in Berkeley, California, and raise 4 children together. Jeffrey Zerillo and Paul Katami reside in Burbank, California. Plaintiffs seek to marry their partners and have been denied marriage licenses by their respective county authorities on the basis of Proposition 8. No party contended, and no evidence at trial suggested that the county authorities had any ground to deny marriage license to plaintiffs other than Proposition 8. Having considered the trial evidence and the arguments of counsel, the court, pursuant to FRCP 52A, finds that Proposition 8 is unconstitutional and that its enforcement must be enjoined. Background of Proposition 8. In November 2000, the voters of California adopted Proposition 22 through the state's initiative process. Entitled the California Defense of Marriage Act, Proposition 22 amended the state's family code by adding the following language: only marriage between a man and a woman is valid or recognized in California. California Family Code, Section 308.5. This amendment further codified the existing definition of marriage as a relationship between a man and a woman in Re marriage cases, California 2008. In February 2004, the mayor of San Francisco instructed county officials to issue marriage licenses to same-sex couples. The following month, the California Supreme Court ordered San Francisco to stop issuing such licenses and later nullified the marriage licenses that same-sex couples had received. See Lockyer versus City and County of San Francisco. The court expressly avoided addressing whether Proposition 22 violated the California Constitution. Shortly thereafter, San Francisco and various other parties filed state court actions challenging or defending California's exclusion of same-sex couples from marriage under the state constitution. These actions were consolidated in San Francisco Superior Court. The presiding judge determined that as a matter of law, California's bar against marriage by same-sex couples violated the equal protection guarantee of Article 1, Section 7 of the California Constitution. The Court of Appeal reversed, and the California Supreme Court granted review. In May 2008, the California Supreme Court invalidated Proposition 22 and held that all California counties were required to issue marriage licenses to same-sex couples. From June 17, 2008 until the passage of Proposition 8 in November of that year, San Francisco and other California counties issued approximately 18,000 marriage licenses to same-sex couples. After the November 2008 election, opponents of Proposition 8 challenged the initiative through an original writ of mandate in the California Supreme Court as violating the rules for amending the California Constitution and on other grounds. The Supreme Court upheld Proposition 8 against those challenges. Strauss v. Horton, 2009. Strauss leaves undisturbed the 18,000 marriages of same-sex couples performed in the 4.5 months between the decision in Re marriage case and the passage of Proposition 8. Since Proposition 8 passed, no same-sex couple has been permitted to marry in California. The procedural history of this action. Plaintiffs challenged the constitutionality of Proposition 8 under the 14th Amendment, an issue not raised during any prior state court proceeding. Plaintiffs filed their complaint on May 22, 2009, naming as defendants in their official capacities California's Governor, Attorney General, and Director and Deputy Director of Public Health, and the Alameda County Clerk Recorder and the Los Angeles Registrar Recorder County Clerk, collectively entitled the Government Defendants. With the exception of the Attorney General, who concedes that Proposition 8 is unconstitutional, the government defendants refuse to take a position on the plaintiff's claims and have declined to defend Proposition 8. Defendant interveners, the official proponents of Proposition 8 under California election law, called proponents, were granted leave in July 2009 to intervene to defend the constitutionality of Proposition 8. On January 8, 2010, Hak-Shing William Tam, an official proponent and defendant intervener, moved to withdraw as a defendant. Tam's motion is denied for the reasons stated in the separate order filed herewith. Plaintiff intervener City and County of San Francisco was granted leave to intervene in August 2009. The court denied the plaintiff's motion for a preliminary injunction on July 2, 2009, and denied proponent's motion for summary judgment on August 14, 2009. Proponents moved to realign the Attorney General as a plaintiff. The motion was denied on December 23, 2009. Imperial County, a political subdivision of California, sought to intervene as a party defendant December 15, 2009. The motion is denied for the reasons addressed in a separate order filed herewith. The parties disputed the factual premises underlying plaintiff's claims, and the court set the matter for trial. The action was tried to this court January 11 through 27, 2010. The trial proceedings were recorded and used by the court in preparing the findings of fact and conclusions of law, and the clerk is now directed to file the trial recording under seal as part of the record. The parties may retain their copies of the trial recording pursuant to terms of the protective order herein. Proponent's motion to order the copies returned is accordingly denied. Plaintiff's case against Proposition 8. The Due Process Clause provides that no state shall deprive any person of life, liberty, or property without due process of law. United States Constitution, Amendment 14, Section A. Plaintiffs contend that the freedom to marry the person of one's choice is a fundamental right protected by the Due Process Clause, and that Proposition 8 violates this fundamental right because, 1, it prevents each plaintiff from marrying the person of his or her choice. 2, the choice of a marriage partner is sheltered by the 14th Amendment from the state's unwarranted usurpation of that choice. And 3, California's provision of a domestic partnership, a status giving same-sex couples the rights and responsibilities of marriage without providing marriage, does not afford plaintiffs an adequate substitute for marriage, and by disabling plaintiffs from marrying the persons of their choice, invidiously discriminates without justification against the plaintiffs and others who seek to marry a person of the same sex. The Equal Protection Clause provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. According to plaintiffs, Proposition 8 violates the Equal Protection Clause because it discriminates against gay men and lesbians by denying them a right to marry the person of their choice, whereas heterosexual men and women may do so freely, and disadvantages a suspect class in preventing only gay men and lesbians, not heterosexuals, from marrying. Plaintiffs argue that Proposition 8 should be subjected to heightened scrutiny under the Equal Protection Clause because gays and lesbians constitute a suspect class. Plaintiffs further contend that Proposition 8 is irrational because it singles out gays and lesbians for unequal treatment, as they and they alone may not marry the person of their choice. Plaintiffs argue that Proposition 8 discriminates against gays and lesbians on the basis of both sexual orientation and sex. Plaintiffs conclude that because Proposition 8 is enforced by state officials acting under color of state law, and because it has the effects plaintiffs assert, Proposition 8 is actionable under 42 U.S.C. 1983. Plaintiffs seek a declaration that Proposition 8 is invalid and an injunction against its enforcement. Proponents' defense of Proposition 8. Proponents organized the official campaign to pass Proposition 8, known as ProtectMarriage.com. Yes on 8, a project of California Renewal, Protect Marriage. Proponents formed and managed the Protect Marriage campaign and ensured its efforts to pass Proposition 8 complied with California election law. After orchestrating the successful Proposition 8 campaign, proponents intervened in this lawsuit and provided a vigorous defense of the constitutionality of Proposition 8. The ballot argument submitted to the voters summarizes proponents' arguments in favor of Proposition 8 during the 2008 campaign. The argument states, Proposition 8 is a simple and straightforward. Proposition 8 is about preserving marriage. It's not an attack on the gay lifestyle. It protects our children from being taught in public schools that same-sex marriage is the same as traditional marriage. While death, divorce, or other circumstances may prevent the ideal, the best situation for a child is to be raised by a married mother and father. If the gay marriage ruling of the California Supreme Court is not overturned, teachers could be required to teach young children that there is no difference between gay marriage and traditional marriage. We should not accept a court's decision that may result in public schools teaching our kids that gay marriage is okay. While gays have the right to their private lives, they do not have the right to redefine marriage for everyone else. In addition to the ballot arguments, the Proposition 8 campaign presented to the voters of California a multitude of television, radio, and internet-based advertisements and messages. The advertisements conveyed to voters that same-sex relationships are inferior to opposite-sex relationships and dangerous to children. The key premise on which Proposition 8 was presented to the voters thus appeared to be the following. 1. Denial of marriage to same-sex couples preserves marriage. 2. Denial of marriage to same-sex couples allows gays and lesbians to live privately without requiring others, including perhaps especially children, to recognize or acknowledge the existence of same-sex couples. 3. Denial of marriage to same-sex couples protects children. 4. The ideal child-rearing environment requires one male parent and one female parent. 5. Marriage is different in stature depending upon the sex of the spouses, and an opposite-sex couple's marriage is superior to a same-sex couple's marriage. And 6. Same-sex couples' marriages redefine opposite-sex couples' marriages. The state's interest in an enactment must of course be secular in nature. The state does not have an interest in enforcing private moral or religious beliefs without an accompanying sexual purpose. Perhaps recognizing that Proposition 8 must advance a secular purpose to be constitutional, proponents abandoned the previous arguments from the campaign that had asserted the moral superiority of opposite-sex couples. Instead, in this litigation, proponents asserted that Proposition 8(1) maintains California's definition of marriage as excluding same-sex couples, 2, affirms the will of California citizens to exclude same-sex couples from marriages, 3, promotes stability in relationships between a man and a woman because they naturally, and at times unintentionally, produce children. While proponents vigorously defended the constitutionality of Proposition 8, they did so based on legal conclusions and cross-examinations of some of plaintiffs' witnesses, eschewing all but a rather limited factual presentation. Proponents argued that Proposition 8 should be evaluated solely by considering its language and its consistency with the central purpose of marriage in California and everywhere else, to promote naturally procreative sexual relationships and to channel them into a stable, enduring unions for the sake of producing and raising the next generation. Proponents asserted that marriage for same-sex couples is not implicit in the concept of ordered liberty, and that its denial does not deprive persons seeking such unions of due process. Nor, proponents continued, does the exclusion of same-sex couples in California from marriage deny them equal protection, because, among other reasons, California affords such couples separate parallel institution under its domestic partnership statutes. At oral argument on proponents' motion for summary judgment, the court posed to proponents' counsel the assumption that the state's interest in marriage is procreative, and inquired how permitting same-sex marriage impairs or adversely affects that interest. Counsel replied that the inquiry was not really the legally relevant question, but when pressed for an answer, counsel replied, "Your Honor, my answer is, I don't know. Despite this response, proponents in their trial brief promised to demonstrate that redefining marriage to encompass same-sex relationships would affect some 23 harmful consequences. At trial, however, proponents presented only one witness, David Blankenhorn, to address the government interest in marriage. Blankenhorn's testimony is addressed at length hereafter. Suffice it to say that he provided no credible evidence to support any of the claimed adverse effects proponents promised to demonstrate. During closing arguments, proponents again focused on the contention that responsible procreation is really at the heart of today's interest in regulating marriage. When asked to identify the evidence at trial that supported this contention, proponents' counsel replied, "You don't have to have evidence at this point." Proponents' procreation argument, distilled to its essence, is as follows. The state has an interest in encouraging sexual activity between people of the opposite sex to occur in stable marriages because such sexual activity may lead to pregnancy and children, and the state has an interest in encouraging parents to raise children in stable households. The state, therefore, the argument goes, has an interest in encouraging all opposite sex activity, whether responsible or irresponsible, procreative or otherwise, to occur within a stable marriage, as this encourages the development of a social norm that opposite sex sexual activity should occur within marriage. Entrenchment of this norm increases the probability that procreation will occur within a marital union, Because same-sex couples' sexual activity does not lead to procreation, according to proponents, the state has no interest in encouraging their sexual activity to occur within a stable marriage. Thus, according to proponents, the state's only interest is in opposite-sex sexual activity. The trial proceedings and the summary of testimony. The parties' positions on the constitutionality of Proposition 8 raised significant disputed factual questions, and for the reasons the court explained in denying proponents' motion for summary judgment, the court set the matter aside for trial. The parties were given a full opportunity to present evidence in support of their positions. They engaged in significant discovery, including third-party discovery, to build an evidentiary record. Both before and after trial, both in the court and in the Court of Appeals, the parties and third parties disputed the boundaries of discovery in an action challenging voter-enacted initiative. Plaintiffs presented 8 lay witnesses, including the 4 plaintiffs and 9 expert witnesses. Proponents' evidentiary presentation was dwarfed by that of the plaintiffs. Proponents presented 2 expert witnesses and conducted lengthy and thorough cross-examination of plaintiffs' expert witnesses, but failed to build a credible factual record to support their claim that Proposition 8 served a legitimate government interest. Although the evidence covered a range of issues, the direct and cross-examinations focused on the following broad questions. Whether any evidence supports California's refusal to recognize marriage between 2 people because of their sex. All 4 plaintiffs testified they wished to marry their partners, and all 4 gave similar reasons. Zerillo wishes to marry Katami because marriage has, quote, a special meaning that would affect and alter their relationships with family and others. Zerillo describes daily struggles that arise because he's unable to marry Katami or refer to Katami as his husband. Zerillo described an instance when he and Katami went to a bank to open a joint account, and, quote, it was certainly an awkward situation walking to the bank and saying, my partner and I want to open a joint account, and hearing, is it a business account, a partnership? It would just be a lot easier to describe the situation. Might not make it less awkward for those individuals, but it would make it crystallize it more by being able to say, my husband and I are here to open a bank account, unquote. To Katami, marriage to Zerillo would solidify the relationship and provide them the foundation they seek to raise a family together, explaining that for them, quote, the timeline has always been marriage first before family, unquote. Perry testified that marriage would provide her with what she wants most in life, a stable relationship with Steyer, the woman she loves and with whom she has built a life and a family. To Perry, marriage would provide access to the language to describe her relationship with Steyer. Quote, I'm a 45-year-old woman. I have been in love with a woman for 10 years, and I don't have a word to tell anybody about it, unquote. Steyer explained that marrying Perry would make them feel included, quote, in the social fabric, unquote. Marriage would be a way to tell, quote, our friends, unquote, quote, our family, our society, our community, our parents, and each other, that this is a lifetime commitment. We are not girlfriends. We are not partners. We are married, unquote. Plaintiffs and proponents presented expert testimony on the meaning of marriage. Historian Nancy Cott testified about the public institution of marriage and the state's interest in recognizing and regulating marriage. She explains that marriage is, quote, a couple's choice to live with each other, to remain committed to one another, to form a household based on their own feelings about one another and their agreement to join in an economic partnership and support one another in terms of the material needs of life, unquote. The state's primary purpose in regulating marriage is to create stable households. Think tank founder David Blankenhorn testified that marriage is, quote, a socially approved sexual relationship between a man and a woman, unquote, with the primary purpose, quote, to regulate filiation, unquote. Blankenhorn testified that others hold to an alternative and to Blankenhorn conflicting definition of marriage, quote, a private adult commitment, unquote, that focuses on, quote, the tender feelings that spouses have for one another, unquote. To Blankenhorn, marriage is either a socially approved sexual relationship between a man and a woman for the purpose of bearing and raising children who are biologically related to both spouses, or a private relationship between two consenting adults. Cott explained that marriage is a social institution, encompasses a socially approved sexual union and an effective relationship, and for the state forms the basis of stable households and private support obligations. Both Cott and Blankenhorn addressed marriage as a historical institution. Cott pointed to consistent historical features of marriage, including that civil law, as opposed to religious custom, has always been supreme in regulating and defining marriage in the United States, and that one's ability to consent to marriage is a basic civil right. Blankenhorn testified 3 rules of marriage, discussed further in the credibility determination section below. He identified, which he testified had been consistent across cultures and times. 1, the rule of opposites, the man-woman rule. 2, the rule of 2. And 3, the rule of sex. Cott identified historical changes in the institution of marriage, including the removal of race restrictions through court decisions and the elimination of coverture and other gender-based distinctions. Blankenhorn testified changes that to him signified the deinstitutionalization of marriage, including an increase in births outside of marriage and an increasing divorce rate. Both Cott and Blankenhorn testified that California stands to benefit if it were to resume issuing marriage licenses to same-sex couples. Blankenhorn noted that marriage would benefit same-sex couples and their children, would reduce discrimination against gays and lesbians, and would be, quote, a victory for the worthy ideas of tolerance and inclusion, unquote. Despite the multitude of benefits identified by Blankenhorn that would flow to the state, to gays and lesbians, and to American ideals, were California to recognize same-sex marriage, Blankenhorn testified that the state should not recognize same-sex marriage. Blankenhorn reasoned that the benefits of same-sex marriage are not valuable enough because same-sex marriage could conceivably weaken marriage as an institution. Cott testified that the state would benefit from recognizing same-sex marriage because such marriages would provide, quote, another resource for stability and social order, unquote. Psychologists Letitia and Peplow testified that couples benefit both physically and economically when they are married. Peplow testified that those benefits would accrue to same-sex as well as opposite-sex couples. To Peplow, The desire of same-sex couples to marry illustrates the health of the institution of marriage, and not, as Blankenhorn testified, the weakening of marriage. Economist Lee Badgett provided evidence that same-sex couples would benefit economically if they were able to marry, and that same-sex marriage would have no adverse effect on the institution of marriage or on opposite-sex couples. As explained in the credibility determination, section 1 below, the court finds the testimony of Cott, Peploe, and Badgett to support findings on the definition and purpose of civil marriage. The testimony of Blankenhorn is unreliable. The trial evidence provides no basis for establishing that California has an interest in refusing to recognize marriage between two people because of their sex. Whether any evidence shows California has an interest in differentiating between same-sex and opposite-sex unions. Plaintiffs' experts testified that no meaningful differences exist between same-sex couples and opposite-sex couples. Blankenhorn testified one difference. Some opposite-sex couples are capable of creating biological offspring for both spouses, while same-sex couples are not. Psychologist Gregory Herrick defines sexual orientation as, quote, an enduring sexual, romantic, or intensely affectional attraction to men, to women, or to both men and women. It's also used to refer to an identity or a sense of self that is based on one's enduring patterns of attraction, and it also sometimes used to describe an enduring pattern of behavior, unquote. Herrick explained that homosexuality is a normal expression of human sexuality. The vast majorities of gays and lesbians have little or no choice in their sexual orientation, and therapeutic efforts to change an individual's sexual orientation have not been shown to be effective, and instead pose a risk of harm to the individual. Proponents did not present testimony to contradict Herrick, but instead questioned him on data showing that some individuals report fluidity in their sexual orientation. Herrick responded that the data proponents presented does nothing to contradict his conclusion that the vast majority of people are consistent in their sexual orientation. Peploe pointed to research showing that despite stereotypes suggesting that gays and lesbians are unable to form stable relationships, same-sex couples are in fact indistinguishable from opposite-sex couples in terms of relationship quality and stability. Badgett testified that same-sex and opposite-sex couples are very similar in their most economic and demographic respects. Peploe testified the ability of same-sex couples to marry will have no bearing on whether opposite-sex couples choose to marry or divorce. Social epidemiologist Ilyan Meyer testified about the harm gays and lesbians have experienced because of Proposition 8. Meyer explained that Proposition 8 stigmatizes gays and lesbians because it informs gays and lesbians that the state of California rejects their relationships as less valuable than opposite-sex relationships. Proposition 8 also provides state endorsement of private discrimination. According to Meyer, Proposition 8 increases the likelihood of negative mental and physical health outcomes for gays and lesbians. Psychologist Michael Lamb testified that all available evidence shows that children raised by gay or lesbian parents are just as likely to be well-adjusted as children raised by heterosexual parents, and that the gender of a parent is immaterial as to whether an adult is a good parent. When proponents challenged Lamb with studies purporting to show that married parents provide the ideal child-rearing environment, Lamb countered that studies on child-rearing typically compare married opposite-sex parents to single parents or stepfamilies and have no bearing on families headed by same-sex couples. Lamb testified the relevant comparisons between families headed by same-sex couples and families headed by opposite-sex couples, and that the studies comparing these two family types show conclusively that having parents of different genders is irrelevant to child outcomes. Lamb and Blankenhorn disagreed on the importance of biological link between parents and children. Blankenhorn emphasized the importance of biological parents, relying on studies comparing children raised by married biological parents with children raised by single parents, unmarried mothers, stepfamilies, and cohabiting parents. As explained in the credibility determination, section 1 after this, none of the studies Blankenhorn relied on isolates the genetic relationship between a parent and a child as a variable to be tested. Lamb testified about studies showing that adopted children or children conceived using sperm and egg donors are just as likely to be as well adjusted as children raised by their biological parents. And Blankenhorn agreed with Lamb that adopted parents actually on some outcomes outstrip biological parents in terms of providing protective care for their children. Several experts testified the state of California and California's gay and lesbian populations suffer because domestic partnerships are not equivalent to marriage. Baggett explained that gays and lesbians are less likely to enter domestic partnerships than to marry, meaning fewer gays and lesbians have the protection of state-recognized relationship. Both Badgett and San Francisco economist Edmund Egan testified that the state receives greater economic benefits from marriage than from domestic partnerships. Meyer testified that domestic partnerships actually stigmatizes gays and lesbians even when enacted for the purpose of providing rights and benefits to the same couples, to same-sex couples. Cott explained that domestic partnerships cannot substitute for marriage because domestic partnerships do not have the same social or historical meaning as marriage, and that much of the value of marriage comes from its social meaning. Peplot testified that little of the cultural esteem surrounding marriage adheres to domestic partnerships. To illustrate his opinion that domestic partnerships are viewed by society as different from marriage, Herrick pointed to a letter sent by the California Secretary of State to registered domestic partners in 2004, informing them of upcoming changes to the law and suggesting dissolution of their partnership to avoid any unwarranted financial effects. Herrick concluded that a similar letter to married couples would not have mentioned or suggested divorce. The expert's testimony on domestic partnership is consistent with the testimony of plaintiffs who explained that domestic partnerships do not satisfy their desire to marry. Steyer, who has a registered domestic partnership with Perry, explained that there is certainly nothing about domestic partnership that indicates the love and commitment that are inherent in marriage. Proponents did not challenge plaintiff's expert on the point that marriage is a socially superior status to domestic partnerships. Indeed, proponents stipulated that there is a significant symbolic disparity between domestic partnership and marriage. Proponents' cross-examination of several experts challenged whether people can be categorized based on their sexual orientation. Herrick, Meyer, and Badgett responded that sexual orientation encompasses behavior, identity, and attraction, and that most people are able to answer questions about their sexual orientation without formal training. According to the experts, researchers may focus on one element of sexual orientation depending on the purpose of the research, and sexual orientation is not a difficult concept for researchers to apply. As explained in the credibility determination, section 1 hereafter, and the findings of fact, section 1 below, the testimony shows that California has no interest in differentiating between same-sex and opposite-sex couples. Whether the evidence shows Proposition 8 enacted a private moral view without advancing legitimate government interest. The testimony of several witnesses disclosed that the primary purpose of Proposition 8 was to ensure that California confer a policy preference for opposite-sex couples over same-sex couples based on a belief that same-sex pairings are immoral and should not be encouraged in California. Historian George Chauncey testified about a direct relationship between the Proposition 8 campaign and initiative campaigns from the 1970s targeting gays and lesbians. Like earlier campaigns, the Proposition 8 campaign emphasized the importance of protecting children and relied on stereotypical images of gays and lesbians, despite the lack of any evidence showing that gays and lesbians pose a danger to children. Chauncey concluded that the Proposition 8 campaign did not need to explain what children would be protected from. The advertisements relied on a cultural understanding that gays and lesbians are dangerous to children. This understanding, Chauncey observed, is an artifact of the discrimination gays and lesbians faced in the United States in the 20th century. Chauncey testified that because homosexual conduct was criminalized, gays and lesbians were seen as criminals. The stereotype of gay people as criminals therefore became pervasive. Chauncey noted that stereotypes of gays and lesbians as predators or child molesters was reinforced in the mid-20th century and remained part of current public discourse. Lamb explained that this stereotype is not at all credible, as gays and lesbians are no more likely than heterosexuals to pose a threat to children. Political scientist Gary Segura provided many examples in ways in which private discrimination against gays and lesbians is manifested in law and policies. Segura testified that negative stereotypes about gays and lesbians inhibit political compromise with other groups. It is very difficult to engage in the give and take of the legislative process when you think that you are an inherently bad person. That's just not the basis for compromise and negotiation in the political process. Segura identified religion as the chief obstacle to gay and lesbian political advances. Political scientist Kenneth Miller disagreed with Segura's conclusion that gays and lesbians lack political power, pointed to some successes on a national and increased public support for gays and lesbians, but agreed that popular initiatives can easily tap into a strain of anti-minority sentiment, and that at least some voters supported Proposition 8 because of anti-gay sentiment. Proponent Hak-Shing William Tam testified about his role in the Proposition 8 campaign. Tam spent substantial time, effort, and resources campaigning for Proposition 8. As of July 2007, Tam was working with Protect Marriage to put Proposition 8 on the November 2008 ballot. Tam testified that he is the secretary of the American Return to God prayer movement, which operates the website onemanOnewoman.net. onemanOnewoman.net encouraged voters to support Proposition 8 on grounds that homosexuals are 12 times more likely to molest children, and because Proposition 8 will cause states one by one to fall into Satan's hands. Tam identified NARTH, the National Association for Research and Therapy of Homosexuality, as the source of information about homosexuality because he believes in what they say. Tam identified the Internet as the source of information connecting same-sex marriage to polygamy and incest. Protect Marriage relied on Tam and, through Tam, used the website onemanOnewoman.net as part of the Protect Marriage Asian Pacific Islander outreach. Tam signed a statement of unity with Protect Marriage in which he agreed not to put forward independent strategies for public messaging. Katami and Steyer testified about the effect Proposition 8 campaign advertisements had on their well-being. Katami explained that he was angry and upset at the idea that children needed to be protected from him. After watching a Proposition 8 campaign message, Katami stated that it just demeans you. It makes you feel like people are putting efforts into discriminating against you. Steyer, as the mother of 4 children, was especially disturbed at the message that Proposition 8 had something to do with protecting children. She felt that the campaign message was used to sort of try to educate people or convince people that there was a great evil to be feared and that the evil must be stopped and the evil is us, I guess. And the very notion that I could be part of what others need to protect their children from was just more than upsetting. It was sickening, truly. I felt sickened by that campaign. Egan and Badgett testified that Proposition 8 harms the state of California and its local governments economically. Egan testified that San Francisco faces direct and indirect economic harm as a consequence of Proposition 8. Egan explained that San Francisco lost and continues to lose money because Proposition 8 slashed the numbers of weddings performed in San Francisco. Egan explained that Proposition 8 decreases the number of married couples in San Francisco who tend to be wealthier than single people because of their ability to specialize their labor, pool resources, and access state and employer-provided benefits. Proposition 8 also increases the costs associated with discrimination against gays and lesbians. Proponents challenged only the magnitude and not the existence of the harms Egan identified. Badgett explained that municipalities throughout California and the state government face economic disadvantages similar to those Egan identified for San Francisco. For the reasons stated in the sections below, the evidence presented at trial fatally undermines the premises underlying proponents' preferred and proffered rationales for Proposition 8. An initiative measure adopted by the voters deserves great respect. The considered views and opinions of even the most highly qualified scholars and experts seldom outweigh the determination of the voters. When challenged, however, the voters' determinations must find at least some support in evidence. This is especially so when those determinations enact into law classifications of persons. Conjecture, speculation, and fears are not enough. Still less will the moral disapprobation of a group or class of citizens suffice, no matter how large the majority that shares that view. The evidence demonstrated beyond serious reckoning that Proposition 8 finds support only in such disapproval. As such, Proposition 8 is beyond the constitutional reach of the voters or their representatives.